Welcome back, future criminologists. Let us start this discussion with a problem or situation. Patrolman Jaime received a report about a mauling incident. He went to the hospital where the victim was brought. He was informed by the hospital officials that the victim died on arrival. The cause of death was massive fracture of the skull caused by a hard and heavy object. Right after, he proceeded to the place where the mauling incident took place. There, he found a piece of wood with blood stains and hollow block. He was informed by the witness, Edna, that she saw the killing and she pointed to Gabriel as one of the 3 men who killed the victim. The patrolman arrested Gabriel without securing a warrant of arrest. Is the arrest valid? We will answer the question at the end of this video, so watch until the end. Again, welcome back, future criminologists. In this video, I will be discussing the second instance of a valid warrantless arrest, which is hot pursuit arrest. Hot pursuit arrest. Hot pursuit, also known as fresh or immediate pursuit, refers to the urgent and direct pursuit of a criminal suspect by law enforcement officers. Such a situation grants the officers in command powers they otherwise would not have. In the Philippines, hot pursuit arrest is embodied in Section 5B, Rule 113 of the Revised Rules of Criminal Procedure. Section 5B, Rule 113 of the Revised Rules of Criminal Procedure states that a peace officer or a private person may, without a warrant, arrest a person when an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. Requisites of hot pursuit arrest. For this rule to apply, it is required that: first, an offense has just been committed, and second, the arresting officer has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. Let us discuss the first requisite. An offense has just been committed. In order for this kind of arrest to apply, there must be no appreciable lapse of time between the arrest and the commission of the crime. There must be compliance with the element of immediacy between the time of the commission of the crime and the time of arrest. Otherwise, a warrant of arrest must be secured. The Supreme Court in the case of People v. Del Rosario did not appreciate the rule on hot pursuit since the accused was caught a day after the consummation of the crime and not immediately thereafter. Based on this decision, we can safely assume that the arrest must be made within 24 hours after the commission of the crime. Now let us discuss the second requisite, that the arresting officer has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. Aside from the sense of immediacy, it is also mandatory that the person making the arrest must have personal knowledge of certain facts indicating that the person to be taken into custody has committed the crime. What do we mean probable cause in hot pursuit arrest? The probable cause determination of a warrantless arrest is based on the information that the arresting officer possesses at the time of the arrest and not on the information acquired later. So, information before arrest and not information after arrest. In determining the existence of probable cause, the arresting officer should make a thorough investigation and exercise reasonable judgment. What about personal knowledge? What does it mean? Personal knowledge of the facts and circumstances that the person to be arrested committed it means personal knowledge not of the commission of the crime itself, but of facts and circumstances which would lead to the conclusion that the person to be arrested has probably committed the crime. A hearsay tip by itself does not justify a warrantless arrest. Law enforcers need not personally witness the commission of a crime. Law enforcers must have personal knowledge of facts based on their observation that the person sought to be arrested has just committed a crime. What is basically the difference between in flagrante delicto and hot pursuit arrest as to personal knowledge and probable cause? Under Section 5A, Rule 113 of the Revised Rules of Criminal Procedure, the officer himself witnessed the commission of the crime. While Section 5B of the same, the officer only knows for a fact that a crime has just been committed and he did not see it personally. Next, the obligation of the arresting officer after the warrantless arrest, consequences of illegal arrest, period for officers to deliver the person detained under Article 125 of the Revised Penal Code are the same with in flagrante delicto arrest. In flagrante delicto arrest was already discussed in our previous video. I will put the link on the description box. Now, let us discuss the answer to our problem. The answer to the problem is there is a valid warrantless arrest. The patrolman saw the victim dead in the hospital. And when he inspected the scene of the crime, he found the instruments of death, a piece of wood and a concrete hollow block which the killers had used to bludgeon him to death. The eyewitness, Edna, reported the happening to the patrolman and pinpointed her neighbor, Gabriel, as one of the killers. Under those circumstances, since the patrolman had personal knowledge of the violent death of the victim and of facts indicating that Gabriel and two others had killed him, he could lawfully arrest Gabriel without a warrant. If he had postponed his arrest until he could obtain a warrant, the accused would have fled the law as his two companions did. To end, please subscribe to our channel and stay tuned for more videos.